Once a person has passed and their will is registered with the county register of wills, the process of probate begins. The person who has been named the personal representative or executor must contact the court and ensure that the will is properly registered, and then file the requisite accounting of all the property within the will. After the initial accounting is filed, the court will then determine whether the accounting is accurate and whether they choose to accept it. Oftentimes, documents are missing from the accounting, receipts are not provided, and a person from the Register of Wills will reach out to the personal representative and discuss with them the appropriate documents that are needed. One can hire an attorney to do this process, or the personal representative can do it themselves. It is a process which requires a minimum of 3 accountings: the initial accounting, the interim accounting, and the final accounting. During that time period, the personal representative or the attorney involved in the matter is in contact with the Register of Wills. All property must be distributed prior to the closure of the estate. All debts must be answered. All creditors must be responded to. It is a difficult and time-consuming process. Should a person pass without executing a will, or the will is rejected by the county government, the estate falls into a category called intestate. At that point, a case is opened, and the circuit court must determine how the property is distributed. The court will review the family and apply the appropriate statute to determine the manner in which the property will be distributed. The court will also launch an investigation into valuing the property to ensure that there is some type of equitable distribution. The court does not take into consideration anything that was said, anything that was mentioned years ago. The court merely looks at the property and the applicable statutes. To avoid family chaos upon your passing and ensure that your property is distributed in accordance with your wishes, and that the person in charge of the distribution is doing so fairly and accurately, it is best to have a sound foundational estate plan and to check up on it every year. With annual checkups, you ensure that your plan is in accordance with state and federal law and is operating at the most efficient and best way for your descendants. It is hard enough to lose a loved one. It is hard enough to grieve and to be heartbroken over someone passing. An estate plan at least relieves your family of the burden of having to disagree over property, over who is going to get what piece of china. A simple document can resolve all those issues. The best way to avoid probate, frankly, is to get a trust. That way, the trustee is in charge of distributing your property immediately upon your passing. However, should you find yourself in a position of the will being in a state of probate, we are more than happy to assist you. We are here at Z Family Law to guide you through the process and make it as pain-free as possible for you and your loved ones.